Alan Dershowitz, author of the book, The Case Against Impeaching Donald Trump. Sir, welcome back here. It's good to have you back on America's News.
Thank you.
I feel like I'm going to law school today with all these stories out there. Let's get through all three of them, okay? Ivanka Trump's attorneys argue this is not apples to apples. What do you make of that argument?
Well, I think it's hypocrisy on parade. Each side uses whatever arguments they can to help and bolster their partisan position. Look, everybody uses private emails. We now have a list of probably a dozen people in public life who have used emails. Apparently, Ivanka Trump used the emails only for scheduling purposes. There was no classified material. The emails are all preserved. It's a non-issue. It's just partisan bickering. We should not be criminalizing the use of private emails, whether by Hillary Clinton or by Ivanka Trump, and we should put that issue behind us.
Seems to me with the day of technology, we need a better system, and we'll see whether or not that happens in the future. Now, topic number two, on Whitaker and the lawsuit, Democrats are arguing you need Senate approval for him to be the acting AG. The White House says he's in a temporary position, and by law, you can serve there for a period of up to 210 days. And even after that point, you can argue whether he stays on longer. What do you make of that argument, sir?
Well, I think that's right. I think you have to give the president some discretion to fill vacancies. You can't fill a vacancy permanently. The day it occurs, you also need a confirmation process. People forget that Justice Thurgood Marshall, when he was appointed to the United States Court of Appeals for the Second Circuit, served as an interim judge for months before his appointment was confirmed. He had not been confirmed that he was serving as a judge. Throughout history, from the founding, we've had interim appointments. I agree, though, that if the interim appointment goes on for a long period of time, or if major irreversible decisions get made by a non-confirmed interim appointee, that can raise some constitutional questions. But this lawsuit itself is much too broad in its scope, challenging the very concept of an interim appointment for a non-confirmed person.
Let me read to you what Senator Richard Blumenthal, the Democrat from Connecticut, is arguing here on screen. He says this: installing Matthew Whitaker so flagrantly defies constitutional law that any viewer of Schoolhouse Rock would recognize it. Americans prize a system of checks and balances, which President Trump's dictatorial appointment betrays. I'm just a bill on Capitol Hill, apparently. School of Rock.
Well, you know, I think I was in the School of Harvard, not the School of Rock, for 50 years, and I never heard anybody complain about interim appointments. It's such a partisan attack. If this were a Democrat president who made an interim appointment, we wouldn't hear these senators complaining. It's completely partisan. Now, they have a point if it comes to serving for a long period of time, but I suspect the president is anxious to make a permanent appointment, and then it'll be up to the Senate. If the Senate takes a long time confirming, as they have sometimes, then the interim appointment will last longer. But that's in the nature of things. And the Constitution certainly doesn't preclude a president from making a short-term temporary interim appointment.
Let's see where that argument goes. Topic number three on immigration. You know, this is red hot right now. A judge apparently agreeing with a Democratic argument that you do not have to legally enter a port of entry in the United States in order to claim asylum. I think this law can be interpreted sometimes for different people from different countries from overseas. How do you see it, Professor?
Well, I think he has the better of the argument the judge does on the statutory interpretation. There's nothing in the statute that suggests that the president has the authority to overrule Congress. Now, all he's done is given an interim injunction, and so I'm not sure how many people will be affected. Ultimately, he has to make a final decision, but you have to look at the statute. The president's authority is not a constitutional authority. It's limited by statute. If the statute permits asylum seekers to seek asylum, even if they come in illegally, that statutory rule has to prevail. If the president doesn't like that rule, he should go to Congress and have Congress change it.
Okay, just to follow up on that, reading from the Associated Press, in issuing the ban, President Trump used the same powers it writes he used last year to impose a travel ban that was ultimately upheld by the U.S. Supreme Court. Is that where this is going?
I don't agree. I think it's a different power. I think the president does have statutory authority and constitutional authority to decide people can't come in from particular countries. That's within his statutory authority. That's part of the statute that authorizes the president to make those decisions. but there's no comparable provision in the asylum statute authorizing the president to make decisions changing the nature of asylum. Look, it's a complicated and interesting statutory interpretation that could go either way, and I think a judge to get an injunction temporarily is probably the right judicial decision to make. We'll see what happens when the case goes to final resolution. It may get all the way up to the higher courts.
Good stuff, sir. Thank you for coming back today. Enjoy your Thanksgiving.
Thank you.
Alan Dershowitz, we'll see where those arguments go. Okay.